Define proposal. Write the essentials of a valid proposal. Or, what is an offer? State the rules of a valid offer.
A proposal is also called an offer. As per Indian Contract Act, 1872, Section 2A, a proposal is defined as when one person signifies to another his willingness to do or to abstain from doing anything, with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. In contract law, an offer is an indication by one person to another of their willingness to enter into a contract on certain terms. An offer can be made in writing, verbally, or by conduct. To be valid, an offer must contain the following essentials. Intention. The offerer must have a serious intention to make an offer. The offer must not be a mere expression of opinion, invitation to negotiate, or an advertisement. Section 26 of the Indian Contract Act, 1872, states that an agreement is formed when a proposal is accepted by the person to whom it is made. In order to be valid, the proposal must be made with the intention of creating a legal relationship. Case law. In Bafo v. Bafo, 1919, the husband promised to pay his wife an allowance while he was working in Ceylon. However, when the husband returned to England, he stopped paying the allowance. The court held that there was no intention to create legal relations between the parties, and therefore there was no valid offer. 2. Definite terms. The second essential of a valid offer is that the terms of the offer must be definite and certain. This means that the offer must contain all the essential terms of the agreement, such as the subject matter, price, and quantity. Case law. In Scammell v. Austin, 1941, the defendant agreed to sell a car to the claimant for a certain price, but did not specify the make or model of the car. The court held that the offer was too uncertain to be accepted, and therefore there was no valid offer. Communication. The third essential of a valid offer is that it must be communicated to the offeree. This means that the offeree must have knowledge of the offer in order to accept it. Case law. In Carlyle v. Carbolic Smoke Ball Company, 1893, the defendant company advertised a reward for anyone who used their smoke ball and still caught the flue. The claimant used the smoke ball and caught the flue, but the defendant argued that there was no valid offer as the claimant had not communicated her acceptance. The court held that the advertisement constituted a valid offer and the claimant had accepted by using the smoke ball. 4. Invitation to acceptance. The fourth essential of a valid offer is that it must be an invitation to acceptance. This means that the offer must be capable of being accepted by the offeree. Case law. In Gibson v. Manchester City Council, 1979, the council offered to sell a house to the claimant, but later refused to sell. The court held that the offer was not an invitation to treat, but an offer capable of being accepted, and therefore there was a valid offer. Revocation. The fifth essential of a valid offer is that it can be revoked at any time before acceptance by the offeree. However, the offerer must communicate the revocation to the offeree before acceptance. Case law. In Bayonne v. Van Tienhoven, 1880, the defendant offered to sell goods to the claimant, but later revoked the offer. However, the claimant had already accepted the offer. The court held that the revocation. Legal purpose. The offer must be for a legal purpose. Offers that are illegal, immoral, or against public policy are not valid. If an offer contains all of the above-mentioned essentials, it is considered a valid offer. Once the offer is accepted by the offeree, it becomes a binding contract between the parties.